I'm Jason Knutson. I'm one of the lawyers at the Madison office of Havish, and Rotier.
And I'm Guy Dubois. I'm an attorney with Axley Brendelson here in Madison.
We're here talking about an article that you'll see in the Wisconsin Lawyer magazine talking about the relationship of physicians and lawyers and how to make that relationship stronger and work even better. We talked a little bit about preparing the doctors to get ready for whatever the task at hand is, whether it's as a treating physician or a defendant or whatever else in a case, and giving them the materials. What my office does is prepare generally a binder for these doctors to look at, and it includes things like the pertinent medical records. If someone else has issued a report, for instance an IME, and I think it would be useful for them to see that, that will be in there as well. What it does not include is a bunch of material that isn't going to be relevant to the medicine at all. That can be things like the face sheets, a lot of insurance information, things that we can really call out. And then you also have to be careful just not to give them too much information. Remember, these physicians not only have too much to do, but they're more and more used to paperless charts. And so the idea of having to flip through 100 pages of medical records or some other documents again is a real big deterrent to getting them to get to work on your file.
That's right. And that's obviously from the plaintiff's perspective, you want to provide the physician with whatever it is that they're going to need to review in order to support what you're thinking, but the same applies to defense counsel as well. If you're challenging an opinion in a case, you obviously have a reason for doing that. You too have seen something in the medical records that you think counteracts or contradicts the conclusion that that's going to be supported. You want to be prepared to provide that to the physician at their deposition as well too. You have to be a little careful. It's not necessarily going to be a gotcha moment because these people aren't out to play gotcha. They're more interested in an intelligent, informed conversation what the issues are. So if you think that you are aware of other records that maybe undercut a plaintiff's claim, what you want to do is you want to be able to present those. Say, now, were you aware of these things? How do you interpret them? How do they fit into your opinions?
Right, and the doctors really appreciate having that information. They don't like being caught flat-footed at a deposition and seeing some record or note for the first time that they haven't seen. And so that's one way to really motivate them to actually go through some records that aren't their own, is to remind them this is a way for you to know what's out there so you can see what questions are coming. And speaking of motivating the physicians, there are really two things I've seen in my career that separate good lawyers from really good lawyers. The really good lawyers, number one, actually read the cases, and the really good lawyers also spend time motivating and preparing the physicians that they work with. It isn't just a matter of showing up for a deposition and not having done anything to get a doctor ready. The really good lawyers have thought about how this doctor fits in and what they can do to motivate that doctor to make them either an advocate in their case or at least present the way that they need to make the case stronger. And that requires some time. It just requires some time to think about the case and then to think about how to prepare this particular doctor. For instance, if you're dealing with a trauma surgeon, you're not going to have a lot of time. You're probably dealing with someone who's used to a fast-paced environment, and so you really need to give them bullet points to get into it. On the other hand, maybe if you're dealing with a family practice physician, that's someone who does take more time to really get to know their patient and what makes them tick, and that's someone where maybe you can talk about the day-to-day effects that an accident or an injury is having on someone's life, and that will resonate more with that physician. But taking the time to frame the case for the physician makes an incredible difference, I think, in how they end up presenting.
Mm-hmm. And I think a corollary to that, and this also goes back to understanding the medicine underlying it, oftentimes if you're dealing with a serious injury, somebody who's been hospitalized, somebody who's had complications throughout their hospitalization, you're going to be dealing with a number of different specialists. It's not always going to be practical from the plaintiff's perspective or from any sort of perspective to drag all these people in for testimony. You know, sometimes it's necessary, but you also have to have an appreciation. Are you pushing this particular physician outside their comfort zone? The example that I always give is that every personal injury litigator had to take a trust in the state's class. That doesn't necessarily mean that you would feel comfortable, advising on trust in the state's issue. Same thing with docs. Cardiologist may be one of the best cardiologists out there. It doesn't necessarily mean that she has expertise in some other specialty. So you want to bear in mind what the person that you're going to be dealing with really knows and what they're comfortable with, so that you can tease out of them things that remain within their comfort zone.
Yeah, that is a great point. One other thing we should touch on, and it will sound a bit glib, is you got to be nice to doctors' staff. As attorneys, I think we're so used to relying on our staff, and the environment that they work in is maybe a little more callous than some of the healthcare environments that they're in. Physician staff really are gatekeepers for them, and you may never get to a physician if you aren't nice to their staff. You really have to do it. And one of the worst things you can do is just send documents, legal documents, subpoenas, anything else like that, without a heads up to the physician and the staff. They need to know what's coming and what it means. And if you build relationships with physician staff, nurses, secretaries, assistants, it's going to make things so much easier as you start to schedule times to prepare them or even just to get their deposition set.
I think that's right. And again, another point that goes hand in hand with that, and it goes to the idea of civility. We were all told that we need to be more civil with one another. And I think that in the context of dealing among attorneys who are used to arguing, who are, by nature, in an adversarial situation, we interpret civility to mean one thing. Physicians, nurses, they're healers. They really do take that role very seriously. They understand that they're there to help. What they define as civil is probably not what most litigators define as civil. And as a matter of fact, they wonder why we squabble the way we do. So, bear in mind that you're actually dealing with folks who are going out of their way to be nice, caring individuals and may not necessarily be comfortable with an adversarial situation. Yeah, if you'd like to learn a little bit more, obviously we have the article coming out in the February issue of Wisconsin Lawyer, and then I believe Jason and I will be presenting a CLE at the State Bar coming up this spring, I think in May.
Thank you.
Thanks.